Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tudo Hoyani. This morning I want to look back at Judge Maumela and also touch upon some of the interests that we are seeing emerge in this trial. You'll recall that Judge Maumela was the first judge in the MEYIWA trial. This matter had not been allocated to Judge Maumela. He had simply allocated it to himself. Now, the normal procedure is a judge will be allocated a matter to do with the pre-trial preparations. And once that matter is trial ready or certified trial ready, he will then inform either the Deputy Judge President, Obrili Dwaba, this is in the Gauteng Division, Obrili Dwaba, or the Judge President himself, Dunstan Mlambo, that the matter is trial ready, and then either the Deputy Judge President or the Judge President will then make a decision to allocate it to any one judge. It does not have to be allocated to the judge who did the pre-trial preparation to get the trial ready. So in the sense of MEYIWA trial, we saw Judge Maumela just allocate himself this matter after it had been certified trial ready by himself. He never bothered to consult the Deputy Judge President or the Judge President to inform them that the matter is trial ready and put it before them so that they can make the decision to decide on a judge who's going to handle that matter. But one wonders, seriously speaking, one wonders why Judge Maumela allocated this matter to himself. What interest did he have to allocate this matter to himself and go to all the lengths or to ignore both the Deputy Judge President and the Judge President? What motivated him to allocate this matter to himself? Now, a lot of things can be read into that. Because once a judge behaves in that manner and starts allocating matters to himself, something which is unprecedented in the judiciary, it raises a red flag that he had an interest beyond seeing justice being done. Judge Maumela, like the Judge President of the Gauteng Division rightly pointed out, should never have done this. And up to this day, he's undergoing a disciplinary hearing. The last I heard of that disciplinary hearing was sometime last year. I don't know what the fate of that disciplinary hearing is up to now. But I know for a fact that he has been appearing there for his gross incompetence as a judge. Now, the interest proper that Judge Maumela had to allocate this matter to himself is best known to Judge Maumela himself. But if a judge allocates himself a matter in that manner, like I've just alluded to, it raises a red flag because you wonder whether he has been influenced by some people or persons outside the judiciary to deal with that matter in order to follow, or to advance the interests of those particular people. In the case of Judge Maumela, this is why I'm saying the most appropriate thing under the circumstances would be to investigate him. He's been investigated for gross incompetence, and he must be investigated. This matter must be investigated. It cannot just be left alone or just ignored like that. There must be some kind of investigation to find out what interest Judge Maumela had, which culminated in him allocating this matter to himself. Was it some financial gain? Was it to protect certain individuals from, justice? But there was some interest. And that interest is an extra legal interest. It cannot be, founded on anything except on extra legal considerations. So Judge Maumela must be investigated for this self-allocation of the trial to himself. Another thing which is very troubling with the Senzo MEYIWA trial is the emergence of two dockets. And herein comes the issue of interest once more. You'll recall that at the earlier stages of the investigation of this matter, one of the investigators of the matter retired or resigned, former Constable Tapadim, says that two sets of investigators emerged, and this has also been confirmed by Brigadier Gininda. Some took the view that there were intruders into that house, and others took the view that there were no intruders into that house. Now, it would appear that the decision to go with either of the two narratives was to pursue certain interests, because clearly the people behind 375, like former Constable Tapadima, were saying that the investigation did not indicate anything to do with intruders. He is today convinced that there were no intruders into that house and that the only narrative that should have been pursued was 375. In other words, the focus should have been on the people in the house as a starting point. So we have seen a lot of very worrying developments in this trial. Because these people who have pursued 636 have now disclosed that Kelly Kumalo was the mastermind. Gininda has told the court that Kelly Kumalo was the mastermind behind the killing of Senzo MEYIWA. But in spite of that disclosure, Kelly Kumalo remains a free woman. How is that possible? That the foot soldiers, if those 5 accused persons can be referred to as foot soldiers of Kelly Kumalo, find themselves sitting in that dock facing those serious murder charges, when the mastermind is walking the streets of South Africa as a free woman. So clearly the issue of interest there in the choice of what docket to pursue are coming to the fore now. Because clearly those who are pursuing the theory that there were intruders into that house have got some interest in not arresting Kelly Kumalo. If a person has been disclosed by none other than the lead investigator as the mastermind of this crime, only interests known to the investigators and the prosecutors are responsible for the failure to arrest that person. So this trial has been marred by so many interests. From the beginning was Judge Maumela. Now we see certain interests here protecting Kelly Kumalo from being arrested. How do they disclose that Kelly Kumalo was the mastermind? A mastermind is the person who is, ought to be accused number one in that dock, and they don't arrest him. what is this interest that they have not to arrest Kelly Khumalo and charge her? Because according to them, their own investigations have disclosed that she's the mastermind. Nobody's making this up. These are disclosures that have been made in court. But what interest do they have? Or what interest do they have not to arrest her? Having said that, let me thank you for watching this video, and let us, ask ourselves today what these interests are. And in a later edition, like the court is on recess now until the 17th, I'll be bringing you some of these issues. Just to ponder over some of these issues, which have marred the Senzo MEYIWA trial, such that 11 years later, there is still no justice for Senzo MEYIWA inside. Thank you very much, and have a wonderful